It's rather sad and distressing that day in and day out, every day, diverse functionaries, be it government ministers or constitutional functionaries, are attacking not only the NJAC issue, but also the basic structure. First and foremost, why this concerted, coordinated, sudden action? That question is not answered by anybody. Why suddenly this thing? It's been years since the NJAC judgment. Nothing has happened about the basic structure for decades. Suddenly, why? This hints at a much larger purpose, a control freak purpose, a imposition dictatorial approach purpose. Secondly, basic structure is the pride of India and the envy of the world. It's a remarkable invention. Law develops by creativity, by interpretation. It is not that law is written down in black stone and you just pick it out, this line, that chapter. It's an evolving, dynamic issue. Now, law developed by a 7-6 judgment, but was reaffirmed by several judgments after that. It is embedded in our constitution. Now, because of the jurisprudence, not only of Keshwanand, but also Minerva Mills and so many others after that. Today, it's the best bulwark against dictatorship. What is it that you want by attacking it day in and day out? Third, the NJAC cannot become a tool for you because you delay appointments on the one hand. You do not follow the letter and spirit of existing judgment. You don't have the guts to bring in a constitutional amendment in Parliament. You delay Collegium decisions by a second, after a second or even a third reference. And on the other hand, you now ask for a relook at the entire system. Fourthly, without bringing a constitutional amendment, without dealing with it legally, legislatively, you have this absolutely remarkable suggestion that there should be 2 government nominees or 1 government nominee or 3 government nominees, as the case may be, sitting on the Collegium. I think this is sounding more and more sinister each day. It is sounding more and more ridiculous each day. And I think it should be exposed to the people of India for what it is. Nothing but a control freak, imposition, dictatorial exercise.
Actually, the recent communication which has come in the public domain from the Law Minister doesn't appear to be a well understood of the legal position. Either he has not read the judgment, or he's not understood the judgment, or he's being advised wrongly. Because clearly the judgment does not entitle the government to ask for amending the Collegium itself. The MOP only means the system to be followed after the recommendation of the Collegium and what steps to be taken, etc. That does not mean that you can amend the Collegium itself. If he wants to do that, he will have to bring in a law to do that. Whether it will pass the judicial muster, whether it will pass the constitutionality test, that is, of course, a matter which will have to be considered later. So, SCBI is a very important stakeholder in this institution. And accordingly, as president of the SCBI, I have been appearing in the matter before Justice Kaul and have been assisting him in that matter. And although I have my own very strong reservations in the faults in the Collegium system, and I am working for correcting them, but that does not mean that the government should take over.
I do think that the Law Minister's letter was ill-advised. That which is a constitutional provision, that which has been interpreted by several constitution bench judgments of the Supreme Court, cannot simply be set aside by a mere letter. The constitutional provision which has been interpreted to include a collegium of the senior judges who make recommendations on judicial appointments is essentially a judicial body acting in their administrative capacity for making recommendations. The Collegium safeguards the independence of the judiciary. Now, that was sought to be undone by a constitutional amendment by this government. That constitutional amendment was struck down. After it was struck down, there is no way that without a fresh constitutional amendment or other legislative measure, that you can simply say that, why don't you include us in the Collegium of the judges itself? This also goes against the theory of separation of powers. Can you imagine the law minister then writing, saying that, on all matters where the government is involved, why don't you please seat us on the bench itself?